Hello and welcome. In today's episode, we are going to be talking about what to do when a contract is broken. Sad, but it does. It happens. Actually, more frequently than we'd prefer. If you're new here, my name is Taylor Darcy from Think Legal. I help you create the business of your dreams. So welcome. I'm very excited for you to be here, to watch these, and I hope to level up your business through sound legal advice that can help you move in the right direction and have a strong foundation. Let's get started. First and foremost, having a contract is absolutely crucial. I see this happen with a lot of entrepreneurs quite frequently where they don't even have a contract or it's a very poor contract. So if you haven't already drafted a contract or had a contract drafted for you, which is always the preferable thing, because although verbal contracts are binding, there are certain instances in which case you want to have a written contract. And honestly, if it's in writing, it's always better. Now, the problem is many of those in writing contracts that you download from the internet may or may not be very good. So you have to be really careful in what you're doing and how you're doing it so that you're getting protected adequately rather than relying on boilerplate language that may not actually meet the needs of your particular situation. So keep that in mind, that something is better than nothing, but sometimes it's not worth the paper that it's written on if it's done incorrectly, or if it doesn't have all of the necessary provisions, because they have to make it so broad for so many different reasons that it just doesn't fit, right? A custom contract is always going to be worth it. And as I've said many times, and I'll continue to say repeatedly, an ounce of prevention in law is worth a pound of cure. It is by far a lot less expensive to have a properly drafted contract than it is to have to fight a poorly written contract. And of the ones that I see, most contracts are poorly written that are not done by an attorney. Now, that doesn't guarantee that an attorney is going to do a great job at it, but you're more likely going to have a better job done by an attorney than not. So keep that in mind. And it's important to review your contracts consistently over time, because things change. Making sure that you're crossing your T's, dotting your I's, commas in the right place, periods in the right place, grammatically correct is going to go a long way towards making sure that you're protected. Commas make a difference. Language makes a difference. So please don't just think that because you filled out a contract once that you never have to do it again and you just have to keep using the exact same thing you've been using for years. Sometimes that's true, but it's not always, and it's frequently that you need to update your contracts. You don't want to leave a provision in that could hurt you and it end up in court or end up somewhere where you don't want it to be, simply for that reason that you didn't fix the contract. It's very important that you do it. Plus, contract laws change. You don't want to just leave it, because that's typically what it is people are bound by that particular contract. And so if you leave it forever, if the laws change that could be in your favor, you don't want it to hurt you unnecessarily. So number one, if there's been a breach, if somebody isn't upholding their end of the contract, you want to review the contract for possible remedies. And typically that's in the latter half of the contract, probably towards the bottom. Whether there's an arbitration provision, mediation, if there's a fee shifting in case of a lawsuit, there's a waiver provision. And a waiver provision is something that's said that basically if you waive a provision, that it's not waiving the entire contract. And that's a common clause that I put in my contracts that keeps it from negatively affecting one clause and making the whole contract void. So again, this is about creating a custom contract that fits your unique needs. And when it's breached, you should know what the remedies are very quickly. The next thing that you're going to want to do is there should always be a notice provision in there. And the notice provision will tell you how you should notify them of their breach. And so sometimes it can be written, sometimes it can be verbal, sometimes it can be an email, but you want to make sure, again, it's updated, because as technology changes, that's the other thing, is it used to be all things must be in writing, delivered by USPS mail, right? And now you can amend that same contract to include email. So you get the benefit of time and you don't have to worry about whether it gets lost in the mail, so on and so forth. Now, you want to make sure that you're notifying them via email as well as mail, but by having it only strictly as one, then you're running that risk that you didn't do the proper way of notifying you if you don't do extra effort. So make sure that you review the notification provision. You're going to want to notify the breaching party of their breach in writing, and that you're not waiving any provision, that you're notifying them that you're not waiving anything in regards to this breach. So they are not under the impression that it's okay. If too much time can elapse, then there is an argument to be made that it wasn't important enough, so you didn't bother to enforce it. Not saying that's a legitimate argument, but that's what can happen if you don't notify them of their breach quickly within the confines of the contract. Part of that notification is you're going to ask them if they intend to cure the breach. So you're giving them an opportunity to right what is wrong, or if there's a way that you can fix it so that the breach is not going to adversely affect them or you. And sometimes it means that you may have to do what's called a novation, which is a new contract in lieu of the original contract, where you refigure things out to protect both parties. If they don't intend to cure, you don't receive a response, then you're going to want to have an attorney send a formal demand letter via email and certified U.S. mail with return receipt to make sure that they got it and that the notification requirement is met. It's just more evidence that you're mounting an evidentiary trail that can be used later, saying, look, they signed for it, they received it, they chose not to act on it. This is a breach. They're going to breach, right? Or they've already breached, they're not curing their breach. And so then you can move forward with a lawsuit if necessary. When you're filing a lawsuit, you're going to want to make sure that you're prepared for the costs that go with filing a lawsuit. Short version of it is, if it's going to be a fairly low amount, then the small claims court is your best bet. It's the cheapest. It has the most, it's the quickest. It has the least amount of discovery. The downside, there's a couple of downsides to it. So I don't want you to think it's the best. It just is the least expensive. The downside to filing in small claims court for a breach of contract is, with that breach of contract case, number one, at least in California, I don't know about the other states, so please make sure that you're following legal guidance in your respective state. With small claims court, if you're the plaintiff, you can't appeal a decision to court. If you're the defendant, you can. That's kind of a downside to small claims court, if you file there. The other problem with filing in small claims court is that when you file in small claims court, you get a judge that it's not really a judge. It's usually like a commissioner, or it's usually like previously a practicing attorney that hasn't been a judge. So you're not getting the full weight of it. And so occasionally I've seen a lot of bad rulings that come from small claims court. And so you're having a little bit of a risk there that you got to be pretty dang strong. It's got to be pretty dang clear that there was a breach and that you've done what you can. Otherwise, I mean, filing in superior court, gives more discovery options and opportunity for it to be fixed. So you really want to balance that. It's very important that you do file suit if they don't cure. And here's why. Because once someone doesn't complete that, well, a couple of reasons, because you really don't want to be taken advantage of. And if, like, for instance, there's a lot of companies that will file suit no matter what. And for instance, Martha Stewart, if you mess with her, she will sue for nothing. Very little. I shouldn't say nothing. She is not one to just take stuff lying down. And I'm not suggesting you have to be overly litigious, but you don't want to be taken advantage of either. And so you really want to make sure that you're suing if necessary in the proper venue at the proper place. Small claims court being the best place for California anyway, for amounts under $10,000 for money purposes. Again, superior court is better for discovery purposes, and you can have legal representation, and those amounts are between $10,000 and $25,000. So you want to make sure that you're filing in the right place. And some attorneys will charge less because there's less discovery and less opportunity for their labor in a $10,000 to $25,000. Or you can also represent yourself pro se in those instances. It just depends. I don't recommend that, but it's possible. But I do recommend, completing and making sure you're following suit if necessary, and filing suit if there has been a breach. Make sure that it's worth the money. That's really what it comes down to. You don't want to spend more money prosecuting it than you get back from prosecuting it. That's the biggest concern when it comes to filing a lawsuit. If it's a fairly small amount, I wouldn't bother, simply because even in small claims court, you get a win, but it costs you and time and energy and effort. I mean, that's a personal decision you have to make. So you really have to balance the circumstances that you're considering in that respect. The next thing that you're going to want to do is the case, you should do, I guess the best way of discussing would be a moratorium on your contracts each time you need to renew it with either a new vendor or if you have a lawsuit that you're working on. And the reason for it is because each set of facts, you can kind of move and hone that contract to be better. Don't stay stagnant. Don't use a contract that you used from 3 years ago. I know I said this already, but this is very important, that each time that you're doing a contract, that you're not just copying and pasting the previous contract, that you're really sitting down and making sure that it's the exact way that you want it to be said, so that you're not running the risk of it being blatant error, typo, something that makes it ambiguous, something that hurts both parties. You really want it to be very clear and detailed. This is not an area where you just want to scrimp and save by doing a boilerplate contract off the internet. Most of those are really going to give you not much more protection than a verbal agreement because they're too broad. And they can be, if I'm on the other side of it, I can claim that in my pleadings that the contract is too indefinite to enforce. That's why it's important that you do this. The other part of it is that you always want to be improving. You don't want to stay stagnant with your contracts. And I did doc review for a brief period of time, and these contracts were poorly written because they were just trying to get them out the door. And it ended up biting them later for that reason, because they were just trying to get them out the door. So you want to take a very proactive approach to your contracts in light of litigation. So when someone breaches, you don't want to just say, oh, okay, I'm just going to keep on going and taking it however it comes. You want to make sure that if there's a breach and that there's language in the contract that could have contributed to that breach, that you're eliminating that language or changing the language to make sure that you're not going to get taken advantage of again by somebody else breaching that contract. So those are the ways, what you want to do if a contract is breached. If you have any questions, leave them in the comments below. And I look forward to talking with you. Also, if you haven't subscribed yet, please subscribe to my channel and hit the bell icon so you get notified of when I go live. We'll talk to you later. Have a great day.